at the time of war or other public emergency threatening the life of a nation as per Article 15 of the Convention. But the derogation of the obligation shall be permissible to the extent it is strictly required by the exigencies of the situation, that is emergency of the situation. But then too some articles cannot be derogated, like the convention under Article 15 para 2, right to life under Article 2, freedom from slavery and servitude Article 4, freedom from torture or inhuman or degrading treatment or punishment Article 3. Now there are two implementation machinery: European Commission of Human Rights and European Court of Human Rights. This European Commission of Human Rights was basically formed for the observance of the engagement for the protection of the rights consisted in European Commission of Human Rights set up in 1934, European Court of Human Rights 1958, and the Committee of Ministers of the Council of Europe. The 11th Protocol amended Section 2 to 4 of the Convention. A single full-time court was established to strengthen the judicial elements of the system and to speed up consideration of specific cases. This was done. The aim was to simplify the procedure, shortening the lengthy proceedings, at the same time to strengthen the judicial character of the system by making it fully compulsory. Later on, European Court of Human Rights came into operation in November 1, 1998. This court was formed by the acceptance required by the members when 8 members acceptance was required, and the court consists of a number of judges equal to those of the members of Council of Europe, and no two judges could be nationals of the same state. Who can file the case under this European Court? Only those high contracting parties whose national is alleged to be a victim, which referred the case to the Commission and against which the complaint has been launched. Here, the judgment of the court was final and it was binding only on the parties to the case. And this judgment was then transmitted to Committee of Ministers who supervise its execution. The court also has one more activity that the court has the competence to give advisory opinion in certain circumstances. And the court was not bound to give an advisory opinion, but it has the competence to decide whether the request is within the consultative competence. Coming with the case laws, here I have specified only one case laws. If you go to my notes, you will get 2 to 3 case laws and also some more important points on European Convention of Human Rights which you can include in your answer. This is Cyprus versus Turkey 2001. The facts of the case was that Cyprus has raised a case against Turkey in 1994 and decided on merits by the Grand Chamber of the European Court of Human Rights. So this was case by Cyprus against Turkey, and this was decided by whom? The Grand Chamber of ECHR in 2001. The situation was that the Turkish invaded Cyprus and de facto separation of the Mediterranean island. So Turkey carried out military operation in July and August and the continuing division of the territory of Cyprus since that time. So the main fact was that the Turkey invaded Cyprus island and the territory of Cyprus. So what does the court held? The court held that there had been 14 violations of European Convention of Human Rights by Turkey. So which were they? Violation of Article 3 and 5, Violation of Article 8, 13, Protocol 1, Article 1 concerning home and property of displaced Greek and Cypriots. Violation of Article 3, 8, 9, 10, 13, Protocol 1, Article 1 and Protocol 1, Article 2 concerning living conditions of the Greek Cypriots in Carpus region of northern Cyprus. So, the judgment was deciding on possible awarding compensation was postponed, and the judgment on this issue was adopted on 12th May 2014, ordering Turkey to pay 900 lakhs euro to Cyprus. That's all for today's lecture. The notes of this lecture will be soon attached to the description. Thank you. See you for the next lecture.